What is a grand jury? Grand jury decides whether to charge you with a felony offense, and sometimes they'll charge you for a misdemeanor offense, but we'll get to that in a second. So what is a grand jury? It's composed of 12 people from the community. The DA will bring in cases to the grand jury. Usually the DA comes in with a summary of a case. It's usually a summary from a police report. The DA will read that information or make an argument for the grand jury about whether you should be charged, either indicted or not indicted. Legal language, it's called true bill or no bill. If they decide to charge you and you're indicted, that's called a true bill. That means you're officially charged with a felony. No bill means you're not charged. That means that the case will go away. Usually the DA is probably not going to try to bring it in front of a grand jury again, and you can go on your merry way. So an assault, impeding breath case, that's a felony offense in Texas. The DA gets the information from the, let's say, Fort Worth Police Department. So let's say you were charged with the felony offense of assault, impeding breath. And impeding breath means this: you have allegedly put your hands around someone else's neck and you've squeezed and cut off the air supply. So the DA gets that case from the police department. They decide whether they want to move forward. If they decide they want to move forward, most of the time they're going to have to take it to a grand jury, and a grand jury is going to decide whether or not you will be indicted for that offense. Now, for you to be charged with it, a grand jury has to find that there was probable cause. Probable cause that you committed this offense. It can't just be some of the grand jury. It doesn't have to be all the grand jury either. It's 9 of those 12 people. If they believe that there was probable cause that you committed this offense, then you will be charged with this felony assault. Sometimes the grand jury will look at what the prosecutor is asking them to do, and they will say, oh, I don't think it's a felony, but I think maybe it's a misdemeanor assault. So they'll indict you on the misdemeanor assault. So earlier when I said usually when we're talking about a grand jury, we're only talking about felonies, that's true most of the time. But the grand jury can also decide to indict you for a misdemeanor offense as well, based on the same facts. A couple of things that you need to understand. Depending on what county you live in, there are different ways to approach a grand jury. For instance, in Dallas County, the elected DA there allows defense attorneys to present affidavits of non-prosecution to a grand jury, sometimes character letters, and we put together what's called a mitigation packet. In Dallas County, the grand jury prosecutor is required to present the mitigation packet to the grand jury. And in cases like that, they can see your side of the story, plus what the state is arguing on behalf of the police department. Now, in Tarrant County, at least right now, you can only present affidavits to a grand jury. You can't provide the grand jury character letters. You can't even make an argument to the grand jury to why they should no bill the case. And that's an important distinction there. You're really only allowed to do what the elected DA allows you to do in a given county. So Dallas County, I've already told you, you can present what's called a mitigation packet. In Tarrant County, look at things a little different, and you're only allowed to present affidavits. And the reason is this, is because there's no guarantee or there's no right under the Texas Constitution or the US Constitution that you'd be able to defend yourself or to present your side of the story at the grand jury phase, because the grand jury phase is still considered technically as the investigation phase. It's a process that only involves the grand jury members, the prosecutor that's assigned to the case, or the grand jury prosecutor that's assigned to the case, and possibly the police officers, because they're making the final charge decision. Even though you've already been arrested, and that's where it falls in the process, you've been arrested, say for a felony, and then the DA, after you've already been arrested, after you've already been in jail and you bonded out, the DA will present that information to the grand jury and they'll decide whether or not to indict you. One of the misconceptions of the grand jury process is, say if a grand jury decides not to indict you for whatever you've been charged with, that doesn't necessarily mean your case goes away. There's no such thing as double jeopardy. Double jeopardy is if you go to trial and you are acquitted, the state prosecutor cannot come back and try to charge you with the same crime again and get a conviction. That's it. They get one shot. As long as there's a trial, you're acquitted. That's it for the state. However, in the grand jury situation, say a prosecutor takes the case to the grand jury no bills it or decides they're not going to charge you with the crime, the prosecutor can go back as many times as they want to within the statute of limitations to keep presenting that case to different grand juries to try to get you charged with this crime. Now, that's not the reality. Most of the time, in the vast majority of cases, if you're charged with a felony and the prosecutor presents a case to the grand jury decides not to charge you, that's it. The prosecutor's not going to keep going back. Sometimes they will keep trying to get you charged with the crime if it's a high profile case, something that's very important to the DA's office. They believe that you did it and they want the grand jury to charge you with whatever felony. So what is probable cause? What does it mean? It means that there's a reasonable ground that you have committed or you're in the process of committing a crime. So if a grand jury found that there was probable cause that you committed the offense of assault while impeding breath or that you possibly murdered someone. That's the only standard they would have to use to charge you with the crime. Now, once you're charged or once you're indicted, that doesn't mean that you're going to be found guilty and you're going to jail. That just means that starts the process. At that point, you'll start to have court settings where you and your attorney will show up, where your attorney will talk to the prosecutor, the state prosecutor that's prosecuting the felony crime. And at that point, you'll decide 2 pass or 3 pass. Case could possibly still be dismissed. You could go to trial and be acquitted, or you could come to some type of plea agreement where you go on probation. But just because you're indicted under that low standard, that probable cause standard, it doesn't mean that you're guilty. For instance, it doesn't mean you're guilty beyond a reasonable doubt. That's the highest standard that would have to be proved if you went to trial. Probable cause is much lower. If you have any questions about this topic, please leave a comment below, or you can visit versustexas.com.